Hi, my name is Katrina Branscombe, and this is my presentation on criminal procedures and evidence. Evidence is the information that people base their decision on. The rules of evidence are a set of regulations that act as guidelines for judges, attorneys, and law enforcement professionals who are involved in the trials of the cases. These rules are set in place to make sure that the trials are conducted efficiently and to enhance the evidence, but it also guarantees that there's a fair trial. Officers use the term evidence with special meaning since so much of their efforts are concerned with ensuring that physical evidence are usable during the trial. They gather all this evidence and they put it in an evidence locker. Even though witness testimony is considered evidence, most law enforcement are concerned with physical evidence. The prosecution uses evidence to prove that a suspect committed the crime, while the defense uses to prove the innocence. General process of handling evidence. When evidence is collected, it must be handled delicately to ensure that there's no tampering. When investigators start collecting evidence, it starts going through what is called the chain of custody. The chain of custody starts from the time that it was handled to the time it was delivered at the court, and it needs to be logged. When an evidence is found and transported to the police station, it then is taken to an evidence room where it is then logged and tagged. On the evidence tag is the date of booking, incident reports, offense, the number of items, cash, the place it was taken from, the owner, and the signature of the officer who booked the evidence. Once it is tagged, it is deposited in a locker. Anybody who checks out the evidence must log themselves out, including crime lab personnel, to ensure that there is no tampering. There are many different types of evidence, starting with real and physical. This is any material object. This can be a bloody clothes, a gun, a knife, a photograph, a letter, a fingerprint, a latent fingerprint. It pretty much speaks for itself. It doesn't need anyone to describe it. Demonstrative evidence is if I shot Joe Blow and they couldn't find the gun, but they found the bullet casing and they wanted to use a gun of similar make and model to match the bullet casing with the gun, they would use that in trial, and that would be considered demonstrative evidence since it wasn't the actual gun that was used at the scene. Direct evidence is the testimony of a person who asserts or claims to have knowledge of a fact. This is witness testimonies. This is a person who believes they have knowledge that recounts events. Circumstantial evidence is an indirect approach that provides proof of existence of a fact due to a chain of facts and circumstances. This is, for example, if I heard Joe Blow get shot, but I turned to the corner and saw Jane Doe with a gun in her hand, this is circumstantial because I did not see Jane shoot Joe. Scientific evidence is a witness testimony that can prove scientifically that something happened. And trace evidence is hair follicles, paint chips, anything that was transferred to the scene by a person during the crime. Admissibility of evidence relies on two things. For it to be admissible, it must be relevant and it must be authentic. Relevance has to do with keeping, basically since anything can be considered evidence, the relevancy of an item is pertinent to the case. If it has something to do with the case, then it can be admissible. Second thing is it must be authentic. It can't be tampered with, and it should be original. Photographs are like the one exception to this rule, as long as it's not a tainted photograph. Privileged information. For information to be privileged during a trial, it needs to follow these 4 conditions. The parties must believe that their communication is confidential. The confidentiality of the conversation must be essential to the maintenance of the relationship. The community must view it as a protected and promoted relationship. And the injury that might occur if the information is released must be greater than the value of the resolution of the court case. Relationships that are recognized by the community as being privileged are husband-wife, parent-child, attorney-client, physician-patient, psychotherapist and patient, clergy and communicant, police officer and informant, accountant and client, and news reporter and news sources. The holder of privilege can waive their privilege by either disclosing a significant part of the communication or consenting to the disclosure of the communication by somebody else. When an admission and a confession is secured, it must be done voluntarily. An opposing party's admission statements are verbal statements made by a party that can be inferred from a person's demeanor, conduct, or acts, or even silence. This is an opposing party's statements can be anything from acknowledgement of being in a vicinity of a crime scene, but does not necessarily have to incriminate the accused. Sometimes the statements can automatically incriminate them. So, for example, if somebody said, "You're under arrest," and said, "Wait, you can arrest me. I wasn't even in town Tuesday. I didn't say anything about you robbed this place Tuesday. Where did you get that from?" A confession is an admittance of guilt made voluntarily by the accused. This must be voluntarily, or it can be subject to be not used in trial. And that is all I have for you. This is the end of this presentation, and I hope you enjoy it.